Section 504, Protecting Students' Access in Our Schools. A focus of Arkansas education is to completely eliminate discrimination on the basis of disability within all aspects of our school operation. This video brought to you by the Equity Assistance Center within the Office of Legal Services at the Arkansas Division of Elementary and Secondary Education is intended to provide an overview of Section 504 for superintendents, district teams, principals, and school leadership teams. The information discussed does not constitute legal advice, but is a resource and a form of technical assistance to improve the outcome of students with disabilities. Be reminded, schools must also comply with other federal statutes and regulations pertaining to individuals with disability not described in this resource, such as Title II of the Americans with Disability Act and the Individuals with Disability Education Act. For a full interpretation of the school's legal responsibilities, contact a licensed attorney. Since 1985, the Equity Assistance Center has had the responsibility of assisting school systems in their compliance with regulations that prohibit discrimination. Laws such as Section 504 of the Rehabilitation Act of 1973. This statute is rooted in ensuring equal access for individuals with disability, which is related to the concept of equity and fairness. Equity in Arkansas schools mean that students get what they need to have equal access to educational programs. In our schools, consider the achievement outcome of students with disabilities compared to that of students without disabilities. Are there any gaps? Fairness in education improves such outcomes and closes such gaps. In order to treat students fairly and equitably, some adjustments must be made to support their needs. Section 504 is a formal way to achieve fairness and make those adjustments. The Equity Assistance Center assists school systems in identifying gaps in fairness and in their compliance with Section 504. We will discuss the Section 504 federal statute and how it relates to meeting, plans, and due process.
Section 504 does not answer every question about its implementation. What it does is provide an implementation framework. The law does not define every procedure that a school district or charter school will need to fully implement Section 504. Some procedures are not defined by the statute itself, but they are recommended guidance by the U.S. Office for Civil Rights, based on its interpretation. And other procedures are a form of technical assistance suggested by the Equity Assistance Center at the Arkansas Division of Elementary and Secondary Education. There are also procedures that are locally defined by the district or charter school. These locally developed Section 504 procedures should be documented in writing. The decision-making authority of an appropriate Section 504 team is described in the statute. The decisions of the Section 504 team is strongly recognized by the Office for Civil Rights, who enforces Section 504, because the team is deemed most appropriate to determine student individual needs. This organization, from broadly written statutes and regulations down to an individualized support system for students, are all intended to best eliminate disability-based discrimination in educational programs. District administrators and building principals must be aware of Section 504 legal requirements, guidance from the Office for Civil Rights, suggestions from the Equity Assistance Center, as well as be aware of their locally developed Section 504 procedures. Superintendents and principals may not be the ones implementing every procedure and every practice all the way down to the student level, but they are expected to be aware of and understand all aspects so that they can support the Section 504 process.
Section 504 is a nationwide civil rights anti-discrimination law. Its purpose is to eliminate and prohibit discrimination based on a qualifying individual's disability. Section 504 applies to any organization, district, or charter, and their programs or activities that receive federal aid. The initial intent of the statute in 1973 was to prohibit disability-based discrimination. This includes within employment and federally funded areas like airports and public libraries. Now, Section 504 also ensures that students are provided equal access to benefits, educational programming, and activities that a school system provides. It ensures equal access to an education comparable in quality or equally effective to that of students without disabilities. Section 504 seeks to make sure that the access of students with disabilities to educational programs is similar to their peers. In education, Section 504 is concerned about securing an equal opportunity for students with disabilities to achieve equal results as students without disabilities. There is no requirement for school systems to produce equal results, but rather they must afford an equal opportunity to achieve equal results. Gaps in student outcomes might be an indicator that students with disabilities served are not receiving an education comparable in quality or equally effective as their peers. Section 504 requires that students with disabilities have access to a free and appropriate public education. This is known as FAPE. An appropriate education under Section 504 is one where supports are designed to meet the individual education needs of the student with a disability as adequately as the needs of students without disabilities. The supports under Section 504 should be equally effective or equivalent, but not necessarily identical. An appropriate education is one that allows for adjustments or different programs to support the needs of students with disabilities. To be served under Section 504, students must meet the definition of disability in the statute. Students eligible for services under 504 must have a mental or physical impairment that substantially limits a major life activity. To determine if there is a substantial limitation, the student can be compared to peers, particularly those without a disability. The Office for Civil Rights describes that a major life activity is not limited to activities that directly impact learning, but can include hearing, breathing, speaking, processing, and other life functions. It can pretty much be anything we do every day. The impairment does not have to be related to learning, academics, or grades. A formal written medical diagnosis is neither required nor does it constitute automatic eligibility for services under Section 504. A student does not have to be failing in a grade in order to be protected under Section 504 or to receive a Section 504 plan. Student grades, attendance, and behavior are all indicators that a disability might be present, but they are not explicit requirements. Some indicators of a disability are hidden. For example, sleep disorders, depression, and anxiety might not always be observable or obvious. The requirement to be served under Section 504 is to meet its definition of a student with a disability, to have a physical or mental impairment that substantially limits a major life activity. Each school district and charter school has an affirmative duty to locate students with disabilities meeting this definition residing within their jurisdiction and zone. If any employee, parent, grandparent, or any adult suspects or believes that a student has a mental or physical impairment that substantially limits a major life activity, they can request a Section 504 evaluation or submit a Section 504 referral to formally request an evaluation. Superintendents and principals should encourage such requests to ensure the institution meets its obligation. A school system's 504 referral process should not be completely dependent on parent requests for evaluation. What percent of Section 504 referrals are from parents? How many are submitted by school staff? It is the obligation and responsibility of the school to find students that meet this definition. The duty to identify students that meet this definition extends to students in homeschool and private school. But the school does not have to provide FAPE nor implement a plan for these students when they are not enrolled. The district or charter must locate students within their jurisdiction that meet this definition of disability. A school may have students with a disability who do not qualify for services under Section 504 due to not meeting this criteria definition. But the school should still support those students in their needs and provide equity outside of the Section 504 process. This visual represents all students within a school. A portion of these students are students with disabilities that do not meet the definition of impairment described in Section 504 and IDEA. They are represented in the light blue inner ring. The middle gold ring represents the portion of students within a school that have a disability that meets the Section 504 definition and are served under that statute. The inner white circle also represents a portion of students in the school that have a disability. These students meet the definition of disability under IDEA and are therefore served under that statute. This circle is within the Section 504 gold ring because these students also gain protections under Section 504. Students served under IDEA gain the anti-discrimination safeguards under Section 504 because they also meet the Section 504 definition of disability. For the vast majority of students, Section 504 eligibility hinges on whether they have a physical or mental impairment that substantially limits a major life activity. This is often called Prong 1. But there are two other prongs under which Section 504 affords protections. A student eligible for Section 504 under Prong 2 has a record of an impairment. Typically, this student was either correctly or incorrectly determined to be eligible under Prong 1 in the past, but the student has since been exited from eligibility. For example, a student that had bone cancer that went into full remission now wanting to play football is protected from the coach preventing them from playing or trying out because of their record of having bone cancer. The student would have protected equal access to extracurricular activities under Section 504. Prom 3 eligibility under Section 504 is triggered when a student is regarded as having an impairment. Eligibility under this prong is rarely used. An example of this would be if a student who has a family history of tuberculosis enrolls in school. Although the student does not have tuberculosis, their teacher in this example, who is aware of the family history, sits the student in the back of the class, avoids interaction with him or her, and does not allow other students to be in close proximity to him or her. Section 504 protects students from such discrimination. Who's responsible to locate eligible students? Is it the teacher, the principal, the parent? It's everyone, the teacher, the principal, including the nurse, the bus driver, or even food services. Who might better understand how a health concern is impacting a student? Who would best know if the student's disability is limiting their access on and off the bus, or their access in the cafeteria line or at the lunch table? Ultimately, laws and policies do not close gaps for students. Laws and policies do not seek out students in need of support, and laws and policies do not carry out those supports for students. People do. It is the actions of people implementing laws and policies and inquiring on students in need of support.
Once a Section 504 referral is submitted by an employee or a parent, the school system must respond. When a request is made for an evaluation, the request cannot be ignored. The school must either agree to conduct an evaluation and follow their procedures, or notify the parent in writing of the school's refusal to evaluate and explain the reason for the refusal. Before a school refuses an evaluation request, they should hold a referral conference. Before an evaluation request is refused, the school should investigate thoroughly the possible existence of a disability, particularly when the student is showing signs of difficulty in school. To be clear, when refusing a request for an evaluation under Section 504, the school should document and demonstrate that it had no reason to suspect or have any evidence that the student has a physical or mental impairment. Not doing so would be a violation of Section 504. When an evaluation is refused, parents must be informed of the school's due process procedures. A Section 504 evaluation request cannot be delayed nor denied because of a response to intervention process or a desire to test out interventions to see if they aid the student. Students served within the RTI process must be referred or evaluated as soon as there is a suspicion of a disability. Students in RTI cannot be required to complete the RTI process before a Section 504 evaluation request is submitted when there is a suspicion of a disability. Districts and charter schools should detail their Section 504 referral process within their written procedures. A team determines if a student meets the criteria definition by evaluating the student. A team-led evaluation is the school's duty under the law. The school district or charter school will need to schedule the meeting and inform necessary team members and the parent of the meeting day, time, and location. Team members must be knowledgeable of the student, the evaluation data, and available placement and service options. The team could include the Section 504 coordinator, the student's teachers, and others familiar with the student. It could also include the counselor or school nurse, depending on the data to be reviewed. The Office for Civil Rights strongly recognizes the autonomy of a student's Section 504 team. For this reason, no one, including the Section 504 coordinator, superintendents, or principals, should sidestep nor circumvent the team's considerations and processes by allowing unilateral decisions. Parents are integral sources of data about the student and vital participants within the Section 504 process. Parents must be invited and strongly encouraged to attend Section 504 meetings. The Section 504 coordinator should do their very best to schedule so that the parent can attend, rescheduling when needed. The Section 504 statute is silent on the issue of parental consent, but the Office for Civil Rights and courts have consistently required informed parental consent for the initial evaluation. Typically, this evaluation consent is made in writing. For an evaluation after the initial evaluation, parental consent is not required by the Office for Civil Rights. Regarding the team's evaluation of a student, Section 504 describes that it must include a review of a variety of data sources. The types of data to be reviewed is determined by the student's Section 504 team. It might include student work, classroom formative assessment data, student grades, discipline and attendance records, standardized test scores, functional behavior assessment data, special education evaluation results, or any recommendations from parents, doctors, teachers, and others familiar with the student. What the parent is observing at home, as well as their suggestions, are key sources of data. Written documentation of a medical diagnosis is another key source of data for the team. The lack of this evidence from a doctor does not relieve the school from their obligation to locate and support individuals with impairments. Teams should move ahead with an evaluation with other data sources when they suspect that there is a disability, even if medical data is not available. Doctors cannot prescribe educational supports, but can make recommendations to educators. A medical evaluation can be requested by the Section 504 team at no cost to the parent if the team thinks it is needed to develop the Section 504 plan. Similarly, if the Section 504 team determines that an independent educational evaluation is needed, the school district or charter school should obtain it at no cost to the parent. The Section 504 evaluation should include materials that are tailored to assess specific areas of educational need. A comprehensive data review is helpful to an adequate Section 504 process. This review of data determines if there is a substantial limitation. Teams decide if there is a substantial limitation by comparing the quality of the student's education with their peers without disabilities. There is no formula that can determine the presence of a substantial limitation. This must be made on a case-by-case basis for each student by a team knowledgeable about the student. The Section 504 evaluation process should increase the team's understanding of what are the barriers to the student's access. So when can an evaluation occur? The federal statute does not provide a timeline for when the evaluation needs to be completed after parental consent is given. The Office for Civil Rights suggests that it be a reasonable amount of time from when the referral for the student was submitted. Most schools follow the same timeline as IDEA, which is 60 days from receiving parental consent. This is not required but would be in compliance with the Office for Civil Rights. Districts and charter schools should detail their Section 504 evaluation timelines within their written procedures. Students must be re-evaluated periodically, typically every 3 years, to ensure that supports are based on recent data. Evaluations must also occur before a significant change in their placement.
What should the conversation in the meeting look like? Well, during the first Section 504 meeting, the team will ask the first question. Based on the data, does the student have a physical or mental impairment that substantially limits a major life activity? If the team determines no, they document their analysis and reasoning, and there is no need to answer the last two questions. The first question is also used to determine if a student no longer qualifies for protections or services under Section 504. A student may exit Section 504 if they no longer have a physical or mental impairment that substantially limits a major life activity. The first question is not necessary for every Section 504 meeting, if the student is already found to meet the criteria. If the purpose of the meeting is to review the supports, the team should ask questions 2 and 3. After a student is found to be eligible for services under Section 504, the team should identify the skills and areas needing to be supported to ensure access and align those with targeted supports to be listed in the plan. This process ensures that each support is data-based and individualized. Teams should not jump right into discussing accommodations. They should analyze the data, determine if the definition criteria are met, identify the lacking skills, and then align accommodations to support those lacking areas. The meeting environment should be one that is built on trust that everyone has the student's best interests and that is inclusive and values all voices. District administrators and building principals must ensure that educators are adequately trained to be members of a Section 504 team. This includes training on how to identify, collect, and analyze individualized classroom-level data, and awareness of available placement, service options, and student-centered supports. The team must be aware of the need to be equitable and flexible when identifying student-centered adjustments that might be different from others. Such training can occur at regularly scheduled in-service or be job-embedded. An example of embedded training would be to review Section 504 meeting norms prior to Section 504 meetings. All Section 504 training, either when provided to individual teachers or groups, should be documented. Depending on the need and culture, superintendents and principals may need to discuss with educators their mindset regarding fairness. Our own philosophies of fairness can influence how we work with students of various abilities. Our opinion of fairness may impact our willingness to make adjustments for students with disabilities. Discuss with educators that students served under Section 504 must be provided as determined by a team with supports that, at a minimum, ensure them equal access as compared to their peers. Administrators must make sure there is available meeting space for teams, time to achieve compliance, and resources aligned to planned student supports. Superintendents must identify a district-level Section 504 coordinator when they have 15 or more employees. If additional support is needed, school-level Section 504 coordinators or designees can also be identified. Superintendents should make sure that these designated individuals are fully abreast of the statute and the school system's local procedures. Principal support might mean reinforcing or emphasizing the importance of the Section 504 process by modeling expected behaviors of educators or team members, standing in meetings when a coordinator is unavailable, spot checking Section 504 team meetings or Section 504 plans, and spot reviewing outcome data of students served. Are they being supported? Is disability-based discrimination being eliminated? Inspecting what you expect at regular times during the year aids in closing gaps between student outcomes. Both superintendents and principals should provide acknowledgments and suggestions to the Section 504 coordinator and to teams.
Students served under Section 504 become a protected group. If a student is found to qualify after an evaluation, they are afforded protections known as procedural safeguards. These protections or safeguards act as a safety net to prevent disability-based discrimination from occurring. Safeguards ensure that the student's school experiences are fair and appropriate. They are measures that protect the rights of students and parents served under the statute. The Section 504 plan is an example of one procedural safeguard. Pretty much everything being discussed in this presentation is a safeguard: the notice, the referral process, an evaluation by a team, parental access to records and the description of their rights under Section 504, a grievance and impartial hearing process, and a review procedure of the hearing process are all safeguards. Some students will only need the protections and safeguards of Section 504 and not a written Section 504 plan. Students without a written plan can still receive an evaluation, the grievance process, parental access to review records, a review procedure, and all of the other safeguards. Unlike IDEA, Section 504 does not expand the rights of students nor give rights to students. Section 504 provides a safety net of safeguards. It protects students from being discriminated against because of their disability. Section 504 protects students' access to the educational program.
When needed, a student may be provided a Section 504 plan. A plan lists targeted actions provided to the student. Such actions are intended to remove barriers due to a disability that limits their access to what is provided by the school. The Section 504 team must be equitable, attending to the individualized needs of the student. Think of a Section 504 plan as a district's or charter's individualized policy between them and that student. Policies are intentionally specific and rarely, if ever, broad because they need to capture a specific area. Supports and accommodations listed in the plan should be worded very specifically so that everyone is clear, educators and parents, on how the support will be implemented. If the support is only for a specific subject or time frame, or only for virtual or remote learning settings, for example, it should be worded in the plan as such. The plan can include accommodations to support the student. Academic accommodations are variations in the way a student accesses learning without modifying the standards or lowering learning expectations. Expected accommodations for standardized testing must be included within the student's Section 504 plan. It can also include reasonable modifications to policies, practices, or procedures that discriminate on the basis of disability. Modifications to grade level standards are not generally encouraged by the U.S. Department of Education. Rather, students with disabilities should be held to the same high standards as their peers without disabilities. Maintaining high-level standards for students with disabilities can lead to their significant progress across different content areas. To ensure that students served under Section 504 benefit from those high expectations and standards, they should receive systematic and explicit instruction. Section 504 plans do not have to directly relate to learning or academics, but they can also include provisions to support behavior or anxiety, or include food-related or athletic-related accommodations. Section 504 does not delineate the specific types of related services that might be provided to a student. A Section 504 plan could include developmental-related aids and services, such as occupational therapy, physical therapy, and speech-language pathology. For example, a student with hearing loss found not to be eligible under IDEA might need a speech-language pathologist to support equipment issues. If the student's impairment is severe enough to require related services, the Section 504 team should review available data to determine whether the student should be referred under IDEA. The administration of medication can be a related service under Section 504 if the Section 504 team finds that it is necessary to ensure the student can access the school's programs. In such instances, the team, after discussing the purpose of the medication, should plan who will administer the medication and any appropriate emergency procedures. Specialized transportation can be included in a Section 504 plan. There can also be exceptions to school policies that might otherwise have a discriminatory effect on the student due to their disability. For example, if due to a student's disability they exceed the allowable number of days absent from school, the attendance policy or makeup work policy may disproportionately affect the student. Exceptions to attendance policies does not mean providing a free pass for students to leave school for any reason. Specifically written exceptions should detail who the student needs to see prior to leaving and what documentation, if any, is needed to accompany each absence. Monitoring the use of this exception should ensure its appropriate use. The plan can describe a change in the education setting and environment. The federal statute does not specifically refer to the term least restrictive environment, but Section 504 does say that a student with a disability should have the regular educational environment be their academic setting unless, with the use of aids and services, it cannot be achieved. Some examples of a change in environment might be the general education classroom with supports, a separate space within the school such as a quiet area, a special education classroom, at the student's home, or a private or public institution like a day treatment program or a residential treatment program. When students transfer into a new district or charter school with a Section 504 plan, the Section 504 team must review it, as well as any other documentation to determine its appropriateness to support the student. If an evaluation is needed, the school may implement the current plan until a new plan is developed.
So then, how often should the Section 504 team meet to review the effectiveness of student plans? Section 504 does not specifically mention how often there should be a review of the supports listed in a Section 504 plan. The Equity Assistance Center suggests how often depends on each student. For struggling students, the Section 504 team might need to review their plan more often than others. The expectation is that the team meet as often as needed. The annual review of the plan is an efficient practice since school staff, subject matter, and school demands change annually. The Section 504 team should consider the students' changing needs due to the effects of a different classroom subject matter, school demands, and other factors for the coming school year. It is the expectation that the Section 504 plans be effective in providing a free and appropriate public education. This is not to say that a student cannot earn bad grades. Just like their peers, there is no guarantee that a student served under Section 504 will earn A's or B's, or that that student will not fail. OCR described that students with and without disabilities in the same classes and with the same curriculum should be graded using similar standards. The school or charter will review, evaluate, and make adjustments to ensure access to the educational program and an equal opportunity to obtain a similar result, benefit, and level of achievement as compared to students without disabilities. Section 504 plans need to be developed by a team, be data-based, and target a student's needs.
A parent may deny the school from implementing the full Section 504 plan, even after they have consented to the initial evaluation. The school is encouraged to speak with the parent, attempt to address their concerns, and as needed, describe how particular supports were identified as appropriate. If there is no resolution, the school should obtain a parent's denial of placement in writing. If a parent disagrees with one or a portion of the accommodations in the Section 504 plan, the parent can deny the full plan or seek resolution using due process. The Section 504 plan cannot be cherry-picked for implementation by anyone, neither the parent, a student, nor a teacher, because the school will be held liable for what is included and not included in the plan to provide a free and appropriate public education and eliminate discrimination on the basis of disability. No individual can unilaterally revise a Section 504 plan. District administrators and building principals must set the expectation that written and updated plans are distributed to necessary teachers by at least the very first day of instruction to the student, if not prior, for effective planning. In keeping with student confidentiality, they should expect that only pertinent information is shared with individuals that need to know in order to support the student. Superintendents and principals should expect the Section 504 team to consider if staff training is needed to implement the planned equitable supports and services. They should convey the district's expectation that teachers and staff implement the Section 504 plan with its full intent, and that not doing so may constitute insubordination and a professional ethics violation. Section 504 requires local school districts and charter schools to pay for services to make their educational program accessible to students with disabilities. They are legally liable, the same as airports or public libraries, to be non-discriminatory. Unlike IDEA, federal funding is not provided to states for services provided to individuals with disabilities under the Section 504 federal statute, and Medicaid will not pay for services under Section 504. All costs are the obligation of the general school or district budget. Many districts and schools establish a Section 504 line item in their general fund budget to cover necessary evaluations, accommodations, and related services for Section 504. Districts and schools provide the services through their own resources or contract with another public or private agency. Regarding not including something in the plan, OCR states, school districts must make these types of decisions based on student need rather than on concerns about costs of providing the support. Even though the school system is not required to provide the most expensive accommodation, the cost should not be the consideration or the reason for a denial of a particular support or accommodation. The Office for Civil Rights goes further to say that a defense that a needed modification or aid or service would create an undue financial burden is not available in the context of a school district's obligation to provide FAPE under the IDEA or Section 504.
In the context of a school, there can be varying individualized plans to support students. These plans might include individualized education programs, individual health plans, behavior or discipline plans, bullying prevention or safety plans, or Arkansas Student Success plans. If a student is served under IDEA, a separate Section 504 plan is not required, even though the student also gains the protections of Section 504. The implementation of an individualized education program in accordance with IDEA is one means of providing FAPE, a free and appropriate public education, under Section 504. An IEP meeting is sufficient, and a separate Section 504 meeting is not required. The Equity Assistance Center recommends that if a student is being supported with a Section 504 plan and another plan, that those plans be put into a singular plan. The student-centered supports that might be listed in such other plans can be included within a Section 504 plan. At the least, teams should come together and discuss their services to prevent overlap, miscommunication, or conflict. A student success plan will remain a separate document from the Section 504 plan. Students served under Section 504 may have a health or medical condition that requires health interventions. In 2009, the Amendments Act broadened the definition of disability under Section 504. Because of this change, mitigating measures can no longer be considered when determining eligibility for services under Section 504. Mitigating measures are supports that alleviate a student's challenges. For example, the alleviating support of medication, technology, or other aids cannot prevent a student from being served under Section 504. Only the use of ordinary eyeglasses or contact lenses can be considered when determining if the student meets the definition of a disability. Due to the shift in 2009, students served on an individual health plan, which is also called an individualized health care plan, may currently meet the definition of disability under Section 504 because mitigating measures cannot be considered. Such students would then gain access to Section 504 protections and procedural safeguards. Mitigating measures can be used to determine if the student needs a written Section 504 plan or only access to the procedural safeguards. Health interventions and supports may be listed within a Section 504 plan, or the individual health plan can be attached to the Section 504 plan. Regarding disability-based bullying or any form of bullying of a student served under Section 504, while the federal statute does not explicitly mention bullying or harassment, failing to respond to a report of such behaviors can lead to a denial of a free and appropriate public education, FAPE. The school system is required to take prompt and effective steps to both prevent the bullying and harassment before it happens and eliminate bullying-based hostile environments when reported. Of course, there must be full compliance with the Arkansas Bullying Prevention Law. To be clear, in regards to Section 504, the principal, when they become aware of the bullying, should immediately investigate what occurred, promptly determine the effective steps needed to end the bullying and take them, eliminate the hostile environment, and prevent future bullying. Some students with disabilities served under Section 504 may stand out in class or elsewhere in the school because of a difference perceived by their peers. Perceptions, stereotypes, or other factors may increase the likelihood of bullying behaviors. Superintendents and principals should lead the charge in discouraging bullying and harassment, and announce to students, educators, and parents that such behaviors are unacceptable. They should ensure the training of staff, students, and parents on the school's anti-bullying complaint procedures, and when needed, facilitate individual and group discussions on the roles of respect, empathy, and avoiding prejudgment and stereotypes. So what about bullying prevention and the Section 504 team? Well, during Section 504 team meetings, the team should determine if bullying prevention supports are needed in the plan to ensure the students' continued access to the educational benefits provided by the school. After the bullying has been found to occur, the Section 504 team needs to consider if compensatory or rectifying supports are needed. The team must determine if the bullying, the hostile environment, or the disruption to or interference in the educational environment resulted in a denial of a free and appropriate public education, FAPE, and any educational deficits. The Section 504 team should remind educators, parents and students to report bullying if it happens.
Section 504 also prohibits disability-based discrimination in regards to discipline. For this reason, students served under Section 504 cannot be excluded from the educational program for more than 10 days due to misconduct that is the manifestation of their impairment, as this would be a denial of free and appropriate public education. When disciplinary actions that constitute a significant change in placement are proposed, the Section 504 team must meet and reevaluate the student prior to the change in placement. The Office for Civil Rights describes that long-term and in some cases short-term out-of-school suspensions are significant changes in placement that would trigger a reevaluation. A long-term exclusion is described as being removed from the educational program for more than 10 consecutive school days. The Office of Civil Rights describes short-term exclusions as being removed from the educational program for days that total more than 10 school days and create a pattern of removal, whereby the length of each removal, the proximity of the removals to each other, and the total amount of time amount to a method of removal. Regarding a disciplinary school bus suspension of more than 10 days, if the school system has been transporting the student and is not making available any other transportation means, the Section 504 team must determine if the student's misconduct was related to their disability. In rare situations, an in-school suspension for more than 10 days might be a significant change in placement if the student during that time was not provided educational services comparable to the quality of education provided before the in-school suspension. The first step in this reevaluation must include the Section 504 team's review and consideration of the relationship between the student's disability and the misconduct. Section 504 regulations do not specifically state the phrase manifestation determination, but the Office for Civil Rights has described the need for this consideration in their letters of findings to school systems. The Office for Civil Rights does not have established guidelines for manifestation determination reviews, but reviews conducted in accordance with IDEA will reasonably satisfy Section 504's procedural requirements. The phrase manifestation determination means to evaluate the relationship between a student's impairment and the misconduct. The Section 504 team should consider how the impairment impacts the student. The Section 504 team in this re-evaluation should have up-to-date data that would lead to an understanding of the student's current behavior. This could include observations by individuals familiar with the student, discipline history, the incident reports that prompted the review, diagnostic data, or functional behavioral assessment data. Current data is especially key when there are reasons to suspect, based on the student's behavior or other factors, that there are additional impairments beyond the challenges listed in the current 504 plan. The Section 504 team should consider all of the student's impairments and disabilities, including those that have not yet been identified by the Section 504 team. An additional question for teams to consider during this review is, was the conduct in question a direct result of the failure to develop or implement an adequate Section 504 plan. If after the first stage of the reevaluation, the misconduct was found not to be a manifestation of the student's disability, the proposed disciplinary consequence, such as a suspension of more than 10 days or even expulsion, can be issued as long as it is the same punishment for a student without a disability under similar circumstances. Parents need to know how they can respond if they disagree with the outcome. Remind the parents of the school's local Section 504 grievance and impartial hearing procedures, as well as their right to seek external resolution avenues. If the Section 504 team finds that the misconduct was a manifestation of the student's disability, the student's exclusion from the educational program cannot take place. A suspension of more than 10 days or an expulsion would not be allowed, as this would be discriminatory due to the student's disability and deny them a free and appropriate public education. The Section 504 team should then continue their reevaluation. The second step would be to determine if the student's current educational placement is still appropriate and identify any needed supports or behavioral interventions to better support the student in the areas that led to the misconduct. The Office for Civil Rights does not require a manifestation determination if the proposed discipline is any other consequence besides one that would result in a significant change in placement or a denial of FAPE. Schools can be more proactive than what is required by the law. A district or charter can choose to perform manifestation determination reviews at any point. Section 504 regulations direct school systems to determine the needed behavioral support for students when the educational program is not meeting their individual needs. When a student has an impairment with symptoms that present as any form of misconduct, the school, through the Section 504 team, should provide effective support to the student in order to help maintain their placement in the current educational environment. With this in mind, the Equity Assistance Center suggests that prior to assigning any disciplinary consequences, the team consider the relationship between the misconduct and the disability, as this may be one indicator that a student's Section 504 plan is inadequate or not implemented. The Section 504 team may need to identify necessary behavior interventions to support the student, prevent the occurrence of misconduct, and maintain the student's placement in the current educational least restrictive environment. The team may need to develop a behavior improvement plan, also called a behavior management plan, when the student's behavioral difficulties interfere with their ability to access the educational program. Such supports can be included within or attached to the Section 504 plan. Such supports are intended to be proactive and prevent misconduct or teach a desired behavior to replace another behavior. Successful behavior supports or behavior management plans should be based on an understanding of the reason or purpose of the student's misbehavior. This involves an objective analysis of the student's specific action. A functional behavior assessment is one way to achieve this analysis and develop targeted behavioral supports. The Section 504 team may need to design a discipline plan that includes discipline exemptions within or attached to the Section 504 plan in order to ensure the student's access to their program. A discipline plan could exempt the student served under the Section 504 from specific discipline measures described in the local code of conduct for specific infractions. Discipline plan exemptions should list the specific acts of misconduct and the consequences for that misconduct for that individual student. Such supports are intended to be reactive to conduct that has already occurred. For example, let's say a student repeatedly disrupts others or instruction. Their discipline plan could exempt the student from the normal consequence of being sent to the principal's office. The plan could then list the student's individualized consequence of jogging in place for 2 minutes for such misconduct. Some students served under Section 504 may need to have both types of behavioral supports. The Equity Assistance Center advises that a discipline plan should not be in place without a behavior improvement plan proactively supporting the student. Parents must be invited to re-evaluation and manifestation determination meetings as they would be for any Section 504 team meeting, as a key source of data and information about the student. Section 504 does not require the district or charter to provide services to a student served under Section 504 when they are expelled for conduct, unless there is a state law that requires continued services to all students that are expelled. Arkansas Law 616-1406, titled Digital Learning Courses, requires the district or charter to offer digital learning courses or other alternative educational courses to expelled students. If a student participates in the district's or charter's alternative learning program during the expulsion, the district or charter would be required to provide accommodations or modifications under Section 504 to ensure the student's access to the educational programming. Such supports might differ from the Section 504 plan when the student was in a regular school environment. A teacher or administrator that authorizes the use of corporal punishment on a child who is intellectually disabled, non-ambulatory, non-verbal, or autistic may be held liable. Also, be reminded of the student's right to due process for alleged misconduct. Students served under Section 504 still have access to the school's discipline due process procedures regarding appeals to disciplinary decisions, just like other students within the school system. Building principals and anyone administering any form of discipline must all be familiar with these safeguards, as well as familiar with the student's Section 504 status. Bus drivers, coaches, and any individuals that deliver consequences for misconduct must be made aware if a student's Section 504 plan includes behavior accommodations or discipline exemptions. As a principal, how are we tracking the number of days that a student served under Section 504 is excluded from their current placement? As a superintendent, how often do those administering discipline review suspension reports? Section 504 grievance procedures and impartial hearing procedures are safeguards described in the statute. School districts and charter schools are required to disseminate their Section 504 due process procedures. There is a perception that by making grievance procedures or impartial hearing procedures widely known and available, that this will lead to an increase in unsubstantiated or baseless complaints. It has been seen that directing individuals to such processes builds trust and confidence in the school system, that it will be impartial and procedurally consistent with all students and parents. Due process procedures are ways that anyone can request that their concern be formally considered and their perspective valued. It is also a way for the institution to convey its commitment to seek out opportunities to improve its processes and support all students. School systems benefit when they become aware of concerns regarding a student's progress in their program. Retaliation or intimidation because of an individual's expressed concern is prohibited. Retaliation limits the possible reports of discriminatory practices. Maintaining a culture of fear to report restricts the district and charter's ability to identify or rectify unfair practices. If concerns, disagreements, or complaints between parents and Section 504 teams arise, district administrators and principals should informally mediate between parents and educators, and when needed, direct parents to the school system's internal due process procedures. District administrators and building principals should be familiar with the specifics of these due process procedures in their school system. A formal complaint is called a grievance. Section 504 grievance complaints may be submitted by parents and must be resolved promptly and equitably. To make this available to parents, the school system must adopt Section 504 grievance procedures. Section 504 grievance procedures must incorporate appropriate due process standards. The Office for Civil Rights suggests that a school system's procedure should state where to file complaints, describe the steps the district or charter will take to ensure an adequate, comprehensive, reliable, and impartial investigation, allow the opportunity to present witnesses, have reasonable and prompt timeframes, provide for a written description of the investigation's outcome, and state an assurance that the district will take steps to prevent discrimination from recurring and to correct its efforts when necessary. An impartial hearing is sometimes called a due process hearing. Both the district and charter or a parent may request an impartial hearing under Section 504. For example, if a parent does not consent to an initial evaluation or refuses the implementation of the Section 504 plan, the district or charter can, but are not required, to request an impartial hearing to seek to override the parent's refusal. Be reminded, if the student is also served under IDEA, that hearing request must be in accordance with that statute. If a parent suspects that the school system was not in compliance with Section 504 or disagrees with a Section 504 team's decision, they may request an impartial hearing. An impartial hearing is presided by an impartial hearing officer. This individual must be knowledgeable of the Section 504 law. A district employee cannot serve as an impartial hearing officer, nor can the officer represent the district or charter in any way. The impartial hearing officer must be identified by the school system. This officer has the authority to issue subpoenas, administer an oath, and examine witnesses, define the issue being considered, and determine the way the evidence is presented. The decision of the impartial hearing officer is binding on all parties involved and implemented immediately. It is the responsibility of the party that requested the hearing to prove the facts of their issue. School districts can adopt the same impartial hearing procedures as provided under IDEA, but are not required to do so. If a parent disagrees with the identification, evaluation, or placement decision of a Section 504 impartial hearing officer, or feels that the process was not in accordance with written impartial hearing policies, they may access the school's internal review procedure. Parents of students served under Section 504 have a right to the opportunity for a review of the decision made at the impartial hearing. The review of the impartial hearing process and decision might be based on and include an analysis of the information described in the written review request, any additional information provided by the parent, the hearing officer's decision, the district's local procedures, the Section 504 statutory safeguards, and any additional information deemed relevant by the reviewer. The outcome of the impartial hearing decision review should be sent to the individual requesting the review.
Those opportunities are managed by the school system, but external resolution avenues are also available to parents. A complaint may be filed with the Equity Assistance Center here at the Division of Elementary and Secondary Education. The Equity Assistance Center guides school districts and charter schools along with providing technical assistance to the institution. A complaint can also be filed with the Office for Civil Rights, who maintains the ultimate responsibility for enforcing Section 504. The Office for Civil Rights is largely concerned on if the district or charter complied with the process and safeguard requirements, such as the use of a team, affirmative duty to locate, evaluate, and making available the due process procedures. A complaint may also be filed in a federal court.
Students served under Section 504 cannot be excluded from an extracurricular activity if they are qualified to participate. They must have an equal opportunity to benefit from such programs. Participation decisions cannot be based on presumptions or stereotypes of the student with a disability. Assumptions regarding a student's ability or skill level based on their impairment should not occur. Rather, decisions should be made on fact and actual performance. For example, a student that has an arm-limb difference should not be denied the opportunity to try out for the basketball team because of assumptions of their ability to bounce or maneuver with the ball. Or a student with characteristics of autism should not be denied the opportunity to audition for a role in the school play because of perceptions of their ability to memorize script lines. An equal opportunity does not mean that schools are required to allow students with disabilities participation in activities when there is a participation criteria in place for all students. Students with disabilities must be allowed to try out, but it does not require that they make the team. The Office for Civil Rights suggests that school systems provide broad opportunities to include students with disabilities to the maximum extent appropriate, Unnecessarily separate or different services or activities may be discriminatory. For example, separating esports athletes with hearing impairments into a different team with different practice and game times because they are provided interpreter accommodations might be unnecessarily separate. The Office for Civil Rights suggests that school systems modify an activity when the modification does not fundamentally alter the nature of the activity. Adjustments and accommodations shouldn't give a competitive edge or an unfair advantage. Some examples of this would be changing standards or qualifying times that would result in lowering the skill level. These are examples of fundamental alterations. Adjustments that do not provide an advantage could be a visual cue for a track athlete with a hearing impairment, or allowing one-hand touch for a swim athlete with one hand. Most sports have already thought out accommodations to increase the inclusion of individuals with disabilities. There can still be required levels of skill and ability in competitive programs that a student served under Section 504 would have to meet to participate, just as long as the requirements do not discriminate on the basis of disability. The athletic director should be even-handed when applying athletic restrictions and not apply a punishment to a student with a disability, but when a student without a disability is in a similar situation, the punishment is not applied. Superintendents and principals should encourage athletic directors, coaches, and physical education teachers to be familiar with varying athletic accommodations to ensure access to this portion of the school's program. Regarding if there are grades, credit, attendance, or behavior requirements for participation in extracurricular activities, if a student served under Section 504 did not meet the requirements due to the fault of the school system not providing a free and appropriate public education, they may be due a waiver of those requirements. The Section 504 team must determine if the student received FAPE when the grades and credits were earned. They should ask, was the plan appropriate? Was the plan implemented? The Equity Assistance Center also suggests that teams consider if the student's disability caused poor grades or excessive absences or behavioral problems that resulted in not meeting the activity requirements. If those requirements are waived, the exception needs to be stated in the Section 504 plan. Students with disabilities cannot be excluded from field trips because of a disability or the requirements to manage their condition. The field trip must be provided in a manner so that the student has an equal opportunity to attend and participate. A nurse, nurse substitute, or another employee familiar with the student's needs should attend as needed. Parents cannot be required to accompany students with disabilities on field trips when parents of students without disabilities are not required to attend. Parents can be invited. In the rarest of situations, a student with a disability can be excluded from a field trip if there is an unacceptable risk to the student's health or safety, but the district or charter must be prepared to demonstrate the essential need of this exclusion. Regarding dual enrollment, districts and charters are still responsible for a free and appropriate public education, FAPE, when their students take college classes. The Section 504 team should assess and provide needed supports, including seeking college-level aids and services. If there are accommodations within a student's Section 504 plan that cannot be implemented in the dual enrollment environment, the Section 504 team must seek other ways that the school district or charter can implement to support the needs of the student. For example, if the student has an accommodation for printed notes, but printed notes are not provided in the dual enrollment course, the Section 504 team may plan to assist the student in obtaining the lecture slides or a recording of the presentation. Eligibility for accommodations at the high school level does not automatically ensure that students will meet the criteria to receive accommodations in a college-level dual-credit course. The school district or charter school should communicate to the post-secondary institution the student's current accommodations and monitor implemented supports in the dual enrollment course. High school students can't simply be referred to address disability-related issues directly with the college or university in a dual enrollment course. Regarding advanced placement exams, if the district or charter requires the exam, then the school system, such as the high school counselor, must submit accommodation requests or provide to students information on how to request accommodations. Regarding ACT and SAT accommodations, the organization that actually administers the ACT or SAT has the sole authority to determine which students are entitled to disability-related testing accommodations. The district or charter has the obligation, if they are involved in the test registration process, to request accommodations by the set deadline. This could also include an obligation to describe to parents and students what documentation is needed to attach to their application for accommodations. Not every accommodation within a student's Section 504 plan will be a granted testing accommodation. The makers of each specific exam or assessment has the sole authority to make this decision. Post-secondary institutions receiving federal financial assistance must comply with Section 504, but high school Section 504 plans do not travel or transfer with the student to colleges or universities. The federal statute does not require a written Section 504 plan. Post-secondary schools are not required to provide a free and appropriate public education, FAPE, but they are required to provide appropriate academic adjustments as necessary to ensure that they do not discriminate on the basis of disability. For example, if the post-secondary school provides housing to students without disabilities, it must provide comparable, convenient, and accessible housing to students with disabilities at the same cost. Unlike in elementary and secondary education, a post-secondary school is not required to identify students as having a disability or to assess their needs. The college or university must be informed that a student has a disability and needs an academic adjustment. For specific questions regarding what supports they will provide, contact the higher education institution directly. Inquire on and follow their procedures to request an academic adjustment. Regarding other documents used as procedural safeguards to comply with Section 504, there is the Notice of Non-Discrimination. A school system must have a statement of non-discrimination. This notification should explicitly state that the school system does not discriminate on the basis of disability in its program or activity. It should also state their duty to identify and locate every qualified student with a disability residing in their jurisdiction. This notice should direct anyone with questions regarding Section 504 to contact the district or charter's Section 504 coordinator. The notice should include the name or title, office address, email address, and telephone number of the Section 504 coordinator. The notice can also include the contact information to the Office for Civil Rights. District administrators and building principals must ensure that such notices are displayed in visible locations. Notices should be posted within documents such as handbooks, newspapers, magazines, memoranda, and recruitment materials. The notice should be widely distributed and in varying ways. Such notices are intended to spread the word of the available supports, the school system's processes, who to contact for concerns, and the school system's explicit intent to not discriminate on the basis of disability. Superintendents and principals must convey that the district and charter does not discriminate on the basis of disability and that there are supports available. There can be a single non-discrimination notice covering Section 504, the Americans with Disabilities Act, Title VI, Title IX, and other federal laws. A combined notice, in order to comply with all federal statutes, needs to have a statement of non-discrimination that specifies each particular type of discrimination that is prohibited, the identification and contact information of each employee responsible for coordinating compliance, and any other specific language according to each statute. There is also a notice requirement for other qualified individuals with disabilities, and not just students found to be eligible for services. An individual with a disability must be made aware of the location of facilities or services that address different accessibility needs. An example of this would be, at entrances where there are stairs and no ramps, a posting of where there is other access available that can be used, or a notice on the website on how it might be used by those with hearing or vision impairments. This also includes available accessible restrooms and assistive listening devices. School systems that have thought of ways to make their facilities and programs accessible must adopt procedures to provide notice of the availability of these accommodations. All parents should be notified of the school system's Section 504 requirements, such as the school system's duty to locate students with disabilities, the contact information of the Section 504 coordinator, and available due process and grievance procedures. Regarding procedural safeguard notices provided to parents, Section 504 does not identify the specific circumstances for which the school system is required to provide written notices to a parent, but the Office for Civil Rights suggests that parents be informed through a notice of actions provided by the district or charter. Such actions could include if a Section 504 referral was submitted by an employee, when an evaluation or other meetings are scheduled, and Section 504 team determinations and placement decisions. To ensure clarity and communication, parents at every meeting may be provided a copy of the rights of students and parents served under Section 504 and a copy of the school system's grievance procedures and impartial hearing procedures, and a copy of the student's Section 504 plan. Evidence that a parent received a copy of their procedural safeguards can be a signed and dated copy of the document kept by the school. So how long should a school maintain Section 504 student files? The Section 504 statute does not dictate a time frame for which records must be maintained. The Equity Assistance Center recommends that districts and charters comply with Arkansas rules and other federal record requirements. The Arkansas Department of Education rules on student permanent records requires that records be kept until the student graduates or would have graduated if the student is no longer enrolled. The Family Educational Rights Privacy Act, FERPA, prohibits the destroying of any educational record when a request has been made for the record. The Equity Assistance Center encourages Section 504 teams to document their team's analysis and the data-informed basis of their determinations in such records. District administrators and building principals must ensure that as students progress in school, enroll, or withdraw from the school system, that there is an easy process for Section 504 records and plans to be efficiently transferred within the district and outside the district, including within and outside of Arkansas. There should be a quick and organized process where Section 504 records follow the student when they enroll, withdraw, and transition to schools and grade levels. Section 504 does not explicitly require that all Section 504 procedures be written, but the Equity Assistance Center recommends that they be in writing to ensure clarity and consistency. Pertinent sections of these procedures and forms should be included in the student handbook and other documents made available to parents. For example, the Section 504 referral form might be included in student enrollment and registration paperwork. The school system's Section 504 procedures should be easily accessible. The Equity Assistance Center suggests that they be one click away from the main website page. Can your school community, including parents of homeschool and private school students, easily access your Section 504 procedures? Section 504 requires that facilities and buildings, roads, parking lots, equipment, classrooms, offices, restrooms, cafeterias, auditoriums, playgrounds, sidewalks, and doorways be accessible to and usable by qualified individuals with disabilities. The steps that a school district or charter school must take depends on the date of the building's construction or last modification. Section 504 defines an existing facility as a facility constructed before June 3, 1977. The school system is not required to ensure that every area of an existing facility be accessible, but they must make sure that the programs and activities are available and possibly provide reasonable modifications. This could include relocating classes, installing specific equipment, assigning an aide, or removing round doorknobs to ensure access. If a facility is constructed or altered after the 1977 date, it is called a new construction. In these instances, a readily accessible standard applies, and the facility must be physically accessible. This could include required width of bathroom stalls, how steep a ramp might need to be, and the required height of countertops and tables. Remember, school systems must also comply with Title II of the Americans with Disabilities Act in regards to physical accessibility. School systems that provide online content and other technology must also ensure that they do not have technological barriers that deny participation to individuals with disabilities. Websites and social media pages are subject to accessibility rules. Section 504 does not require a particular accessibility standard, but districts and charter websites are encouraged to adhere to the Web Content Accessibility Guidelines or the standards listed in Section 508 of the Rehabilitation Act. The WCAG 2.0 has a range of recommendations for making web content more accessible to individuals with disabilities. Section 508, which comes from the same law as Section 504, specifically concerns how information technology is maintained by federal agencies. Superintendents should get with their webmaster to make sure that they are meeting either of these guidelines. Some common Office for Civil Rights website accessibility findings include images missing text descriptions, computer mouse only navigation that only allows keyboard users access, inappropriate color combinations for the visually impaired, and video with no closed captions or inaccurate captions.
Section 504 was designed to eliminate discrimination on the basis of disability. This prohibition extends to multiple areas within the school system's educational program. That is why the implementation of Section 504 is dependent upon everyone within the school system. Equitable access requires an environment where there is trust in each other and the Section 504 process. This Equity Assistance Center presentation is not legal advice, and school districts and charter schools should always consult legal counsel regarding the best way to address specific situations. The Arkansas Division of Elementary and Secondary Education Equity Assistance Center has the responsibility of assisting school systems in identifying gaps in fairness and in their compliance with regulations that prohibit discrimination. The Equity Assistance Center provides Section 504 support to all members of the school community, including superintendents and principals. The Equity Assistance Center may be accessed by phone or electronically. For additional videos on Section 504, access the Equity Assistance Center's webpage at the Arkansas Division of Elementary and Secondary Education.